Assalamualaikum warahmatullahi wabarakatuh. Hello everyone. Today we are going to present our topic about the British legal system. This topic will help us understand how law and justice work in the United Kingdom and how the system has developed over time. Alright, let's start with the first part, the structure of the United Kingdom's legal system. The first point is Britain does not operate under one common legal system. Instead, its structure consists of distinct legal elements shaped by history and political development. This means that, unlike many other countries, Britain's law is not unified but divided into several legal systems that coexist within one state. There are three separate elements, those of England and Wales, Scotland, and Northern Ireland. Each of these three systems has developed its own legal tradition and structures. England and Wales share one system, while Scotland and Northern Ireland maintain their own. This reflects the way in which regional identities and historical independence continue to influence the law within the United Kingdom. And the next point is they often differ in their procedures and court names. The main distinction appears in the way courts are structured and how cases are processed. For example, Scottish courts use different names and procedures from those in England and Wales. These differences show the regional diversity that exists within Britain's legal framework. And next, some laws are only applicable to one of the nation. Because each system functions separately, certain laws only apply within one part of the United Kingdom. For instance, legislation specific to Scotland or Northern Ireland may not apply to England and Wales. This is a direct result of their distinctive judicial and legislative powers. Next point. Although powers have been developed to regional government, the Westminster Parliament in London still holds primary authority over major legal areas. Therefore, a significant amount of Westminster legislation continues to apply across the United Kingdom, particularly in matters of national concern such as defense or foreign policy. And British court cases are divided into civil and criminal law. Civil law deals with private rights and resolves disputes between individuals or organizations, usually through compensation or settlement. Meanwhile, criminal law protects society by punishing those who commit offenses against the state, such as theft or murder. Together, they form the foundation of the British legal system.
The English legal system is one of the oldest and most traditional institutions founded on independence from executive and legislative power. The English legal system stands as one of Britain's oldest and most enduring institutions. Its authority is rooted in its independence from the executive and legislative branches. Historically, it was designed to protect citizens, uphold justice, maintain public order, and support legitimate government. Early courts were centered in London, dealing with extrajudicial criminals and civil law before local courts and magistrate justice of the peace were established. In its early development, the English courts were mainly based in London and handled church, criminal, and civil matters. As the need arose to apply national law more effectively across the country, local courts and magistrates were introduced. By the 14th century, justices of the peace were appointed in each county to manage local justice under the authority of London judges. Population growth and social complexity led to overlapping jurisdiction and inefficiency, prompting major judicial reforms. Over the centuries, population expansion and the rise of complex economic life created a flood of legal cases. This caused overlapping jurisdiction between locals and central courts. To address this, major reforms were introduced to simplify and unify the court structure, ensuring that law could be applied more effectively. Historically, the system faced criticism for favoring the privileged, being costly, slow, and resistant to reform. The English legal system was often seen as favoring property and political interests over human rights. Its procedures were lengthy and expensive, making justice difficult to access for the poor. This led to widespread criticism that the law served the elite rather than the society as a whole. Nevertheless, the legal system has evolved over centuries to respond to social change and public demand. Despite its flaws, the legal system has shown resilience and adaptability through continuous reforms. It has adjusted to the new social philosophies and public expectation, reflecting the growing interaction between law and everyday life. Two fundamental principles shape its development. The first is law is administered by the state through national courts, and the second is judges must remain independent from royal and political control. These two core principles became the foundation of English and later British legal history. State administration ensures national consistency, while judicial independence safeguards fairness and prevent interference from political or royal power. Major reforms in 1873 to 75 and 1970 to 1971 unified the court structure and reinforced judicial independence established under the Act of Settlement. The court reform of 1873-75 reorganized the judicial system into a coherent structure, making legal procedure more efficient. Further reforms in 1970-71 refined this framework together. This reform strengthened the long-standing principle of judicial independence, first guaranteed by the Act of Settlement of 1701.
Next, sources of British law. There are main sources of English and Welsh law. The first is common law, based on judicial precedent. Common law is the oldest foundation of English law, originating from the customs of early settlers and developed further after the Norman conquest. It evolved into a body of principles established by judges through their ruling in court cases. Judgment became a precedent, serving as a reference for future cases. This tradition of following precedent ensures consistency and continuity within legal system. Though it is sometimes criticized for becoming conservative and slow to adapt to social change. And second, statute law. Laws made by the Parliament of Westminster. Statute law refers to laws enacted by the Westminster Parliament, which gradually replaced the monarch's dominance in lawmaking. As society grew more complex during the 19th and 20th centuries, the number of statutes increased to address emerging social and economic needs. Today, most British law take the form of statutes, reflecting the state's influence on citizens' daily life. Acts of Parliament passed at Westminster often apply not only to England and Wales but also to the wider United Kingdom, standing most other forms of law except in certain matters covered by European law. And the third, European Union law, EU law, effect since 1973 before Brexit. European Union law became part of British law after the United Kingdom joined the European Economic Community in 1973. Within specific areas, EU law took precedence over domestic legislation, requiring British judges to apply EY provisions whenever conflicts arose. Although the UK's withdrawal from the EU, Brexit, has changed this relationship, the influence of EU laws remain visible in many aspects of British legal practice and interpretation. And there are the legal system of Scotland and Northern Ireland. The first, Scottish law, rooted in Roman and English legal tradition. Scottish law developed as a distinct system influenced by both Roman and English legal principles. Its main sources include judgment law, authoritative legal treatise, European Union law, and legislation. The first two, collectively known as Scots common law, are comparable to the English common law tradition. In addition to Westminster statutes, the Scottish Parliament has legislative authority over developed matters, reflecting Scotland's partial autonomy within the United Kingdom. And the second, Northern Irish law. Following the common law tradition, the legal system of Northern Ireland shares many similarities with that of England and Wales. as it also follows the common law tradition. Since 2000, the Northern Ireland Assembly has exercised both legislative and executive powers over devolved matters, allowing it to make laws specifically for Northern Ireland. This reflects the broader framework of devolution across the United Kingdom, where regional bodies hold authority within defined constitutional limits.
Court system in England and Wales. This is the chart and we will discuss it in the next slide. The civil court in English and Wales. County court handles around 90% of civil cases, deals with money, property, contract, divorce, and family disputes, presided over a district judge, usually sitting alone. The county court is the main entry for civil law in English and Wales. It covers the majority of civil cases, including dispute over contract, debts, property, or family matters like divorce. These courts are spread across many districts, making them accessible to the public. Cases are usually handled by a single district judge, and the procedures are simpler and less costly than in higher court. High Court of Justice deals with complex or high-value cases, divided into three divisions: Queen Bench divisions, contract and negligence; Chancery division, finance, business, inheritance; family divisions, marriage, divorce, and child custody. The High Court of Justice handles more serious and complex civil cases, particularly those involving significant sums of money or complicated legal issues. It is divided into three specialized divisions. The Queen's Bench divisions covers contract disputes and negligence claims. The Chancery division focuses on businesses, financial, and inheritance matters, while the Family division deals with marriage breakdown, divorce, and child custody. This division of work ensures that each case is handled by judges with expertise in the relevant field.
The third Court of Appeal, Civil Division. The Court of Appeal Civil Division provides a higher level of review for civil cases. It evaluates whether the lower court correctly applied the law and whether the decision was fair and reasonable. The court can uphold, reverse, or modify a previous judgment, and in some cases, it may order a retrial. Its role is to maintain consistency and fairness in the civil justice system. And the last, House of Lords or Supreme Court. For civil law, the Supreme Court serves as the final arbiter. Not every case can reach this stage, only those involving issues of both public or legal importance. The court's rulings become authoritative precedents that guide future decisions across all levels of the judiciary, ensuring the coherence and evolution of the British legal system.
Criminal courts in England and Wales. First, Magistrate Court handles summary offences, minor crimes, 95% of total cases. Cases decided by justice of the peace without a jury may transfer indictable offences to Crown Court for trial, can impose fines up to €5,000 or imprisonment up to 6 months. Also handles youth courts for defendants are under 18. The Magistrate Court is the foundation of the criminal justice system in England and Wales. It deals with almost all criminal cases, particularly minor offences like petty theft or traffic violations. The trials are usually decided by justice of the peace, who are not professional judges but citizens trained to carry out judicial duties. They do not use a jury, and their decisions are based on facts presented in court. For more serious offense, the case will be transferred to the Crown Court. A magistrate can also handle youth case and have limited power of punishment, preferring fines or community penalties over imprisonment. Second, Crown Court deals with serious criminal offense like murder, robbery. Trials conducted before a judge and a jury of 12 citizens. Also hears appeals from magistrate courts located in around 90 cities across England and Wales. The Crown Courts serve as the higher criminal court for serious offences such as murder, rape, or armed robbery. It used the jury system where 12 citizens are selected to decide whether the defendant is guilty or not. While the judge ensures the trial follows legal procedures, the Crown Court also hears appeal from the magistrates' courts, ensuring that lower courts' decision can be reviewed fairly. Its presence in nearly every major city allows criminal cases to be tried efficiently across the country.
The third, Court of Appeal Criminal Division. The Court of Appeal Criminal Division plays a crucial role in safeguarding justice by reviewing cases that may involve errors in law, procedures, or sentencing from the Crown Court. It does not hold new trials but rather examines whether the law was correctly applied. If a mistake is found, the court has the power to overturn the conviction, adjust the sentence, or order a retrial to ensure justice is properly served. And last, House of Lords, Supreme Court. Before 2009, the highest court in the United Kingdom was the House of Lords. Today, that role has been taken over by the Supreme Court of the United Kingdom. It only hears exceptional cases to raise important legal or constitutional questions. The decisions made here become binding precedents that all lower courts must follow, shaping the future direction of British law.
Civil and criminal procedures. First, civil procedures begins with the plaintiff files a claim in county or high court. Decision based on balance of probabilities. Losing party pays the cost. Since 1999, reforms procedures are simpler, faster, and cheaper, encouraging out-of-court settlements. The civil procedure starts when a plaintiff files a claim in court. If the defendant disputed, the case goes to trial. Decisions are made based on the balance of probabilities, meaning which side seems more likely to be right. Since 1999, reform has simplified the process, making it faster, cheaper, and people are encouraged to settle dispute outside of court. Second, criminal procedure. Crown Prosecution Service (CPS) prosecutes independently of the police. Suspect must appear in the court within 24 hours of arrest. Bail may be granted or denied. Public trials follow the adversarial system. Both sides present evidence. Guilt must be proven beyond reasonable doubt. In criminal case, the Crown Prosecutive Service or CPS handles prosecutions independently from the police. After arrest, suspect must appear in court within 24 hours and bail may be given or refused. Trials are open to the public and both sides present evidence under the adversarial system. The prosecution must prove guilt beyond reasonable doubt. Third, the jury. Used in Crown Court for serious crimes, 12 jurors chosen randomly from the electoral register. Majority verdict to 10 to 2, accepted after 2 hours. Juries decide guilty, not sentencing. Viewed as public participation in the judicial system, but criticized for high acquittal rates. Jurors who are received as unsuitable or subjective intimidation of jurors and the need to save time and money. The trials by jury is one of the most traditional elements of the British justice system, mainly used in Crown Court for serious criminal offences. A jury consists of 12 citizens chosen randomly from the electoral register to assess the evidence presented in court. After at least 2 hours of discussion, they can deliver a majority verdict, 10 in favor and 2 against. If they can reach an unanimous decision, the jury system is valued as a way for ordinary citizens to take part in justice, ensuring fairness and community involvement. However, it's also criticized for its high acquittal rates, the occasional bias or inexperience of jurors, and the significant times and costs required for jury trials. 4. Legal aid, established in 1949 to help low-income individuals afford legal services. Applicant must meet financial and case merit criteria. Funding cuts have reduced access to justice. Conditional fee system, lawyers paid only if the clients win. Legal aid was introduced in 1949 to help those who can afford legal fees. Applicant must show financial need and valid case. However, recent funding cuts have limited its availability. There's also a conditional fee system where lawyers are paid only if their clients win, but critics say it benefits lawyers more than clients.
Law and order in Britain. The first is crime and punishment. Crime in Britain takes up around 5% of government spending, make it a major concern. However, crime statistics aren't always accurate since many serious crimes go unreported. Youth crime, drug and alcohol offenses, and gun-related incidents are among the main problems. Public opinion often blames poor discipline, unemployment, and weak policing. The government responds with stricter laws and longer sentences, but confidence remains low. For punishment, first-time offenders might get probation, while others face prison or community service. Since the death penalty was abolished in 1965, prisons have become overcrowded and criticized for poor conditions. There's an ongoing debate about whether the system should focus more on rehabilitation rather than punishment. Second, law enforcement and police. The British police operate under civilian control, meaning they are not a military force. There are 52 regional police forces, each led by chief constable, with the Metropolitan Police handling London. They face challenges like recruitment shortages and low ethnic representation. Officers aren't allowed to strike but can join associations to represent their views. Traditionally, British police are community-based and unnamed, but now they also deal with riots and use the armed units when needed. However, accusations of racism and misconduct have damaged public trust. The government continues to reform the system to improve transparency and community relations.
The legal profession in England and Wales. Solicitors, about 90,000 solicitors, almost in private firms, offering general legal service, can now represent clients in higher courts after reforms, training, university degree plus apprenticeship, 6 years. Complaints handled by a law society controlled body. In England and Wales, the legal profession is divided into solicitors and barristers. Solicitors make up the majority, around 90,000, and they usually work in private firms, providing legal service such as contracts, property, or family law. After reforms, solicitors can now represent clients in higher courts, which used to be limited to barristers. Their training takes about 6 years, including university study and practical apprenticeship. Complaints against them are managed by a body under the Law Society. Barrister, around 10,000 barrister, expert in court advocacy and legal advice, regulated by Bar Council and for ends of court, training, law degree, exam, in membership with training and 1 year pupillage. Work, self-employed, starting as junior barrister, top one become Queen's Counsel, and may later serve as judge. Barristers, on the other hand, focus on advocacy. That means speaking and arguing cases in court. There are about 10,000 of them, and they are regulated by the Bar Council and the Inns of Court. To become a barrister, one must study law, pass exams, join an inn, and complete a 1 year pupillage. Barristers are self-employed and start as juniors, but experienced ones can be Queen Counsel or QCs, which give them higher status, more complex cases, and higher pay. Judges form the independent judiciary, mostly selected from senior barristers, some from solicitors, appointed by the Crown on political advice, often criticized as elitist and male-dominated, serve until retirement. Reform aim to improve the diversity and complaints procedures. Judges come mainly from senior barristers, though some solicitors can also be appointed. They are chosen by the Crown based on political advice, which was drawn criticism for elitism and lack of diversity. Most judges serve until retirement, and recent reforms aim to make the judiciary more transparent and representative. Scotland and Northern Ireland have similar division between advocates and solicitors operating separately. Scotland and Northern Ireland, the system is similar, but the lawyers are called advocates and solicitors operating separately, like in England and Wales.
Attitudes to law and order in Britain. The first, public attitudes toward law. In general, Britain is known as a litigious country. People usually avoid taking legal action because it's expensive and complicated. Lawyers also tend to have a poor reputation compared to other professions. However, more people are now turning to civil law to claim damages or compensation. Despite this, public confidence in the legal system remains low due to long court delays and inefficiency. Interestingly, people abroad often see the British legal system as more effective than the British public does. Second, attitudes toward crime and safety. When it comes to crime, surveys show that public concern is high even though actual crime rates are relatively stable. Many people feel unsafe at night and believe crimes has become worse over the last 10 years. Confidence in the police varies. People are generally satisfied with their local police, but not always with how fast they respond in emergencies. A majority of citizens believe they should have the right to defend their property and that current laws are too soft on criminals.
Conclusion: the British legal system is among the oldest and most respected in the world. It's built on the principle of judicial independence and the rule of law, ensuring that justice stands apart from political power. Although England, Wales, Scotland, and Northern Ireland each have their own legal system, all share a strong commitment to fairness. Over the years, the system has evolved through reforms to meet modern needs. While challenges like high costs and inequality still exist, Britain legal traditions continue to be admired as a symbol of justice and stability. Alright, that's all from us. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.